Public Protector Busisiwe Mkhwebane left the Section 194 inquiry into her fitness to hold office after committee chairperson Qubudile Dyantyi asked evidence leaders to make a presentation to the committee. Mkhwebane has been telling the inquiry she won't be proceeding if she does not have legal representation due to a cash crunch. Now, as a result, the impeachment inquiry has been adjourned pending resolution of the funding of Mkhwebane's legal costs. Let's get analysis on this with legal expert Marius Du Toit. Mr. Du Toit, good morning and thank you very much for your time. Now, before we get to that summary by Advocate Bauer, can we start with just that back and forth between the chair, Advocate Mkhwebane, and some political party members? They were strongly opposed to the decision to have the evidence leader give that summary of the evidence that has been led so far. And this was purely on the absence, because of the absence of Busisiwe Mkhwebane's lawyers. What did you make of just that back and forth?
Okay, Mfundo, I think the first thing we have to say is that in terms of the Concord ruling, the public protector is entitled to be legally represented fully during these proceedings. So the moment she is without her legal representation, and it's not her fault, it's not that we can blame her for having not appointed the legal representative, but we know this is now funded from state coffers. The moment we have that situation, it means that she is now not legally represented, and the proceedings should basically stop. I understand that some of the committee leaders or members want to proceed with the inquiry, but it would be prejudicial to her rights. We must remember that this process must be fair. And when we say this process must be fair, it must be fair in all material respects. So in other words, if she needs to be legally represented, well, then she's entitled to be legally represented, as the Concord has ruled specifically in this point. And therefore, I must be honest with you, I can't see the proceedings continuing without the issue pertaining to the payment of a legal representative being sorted and in being placed in funds so that he can continue on her behalf. Remind yourself that she's occupying public office, and this is an inquiry into her competency as the individual occupying that office. And for that reason, we have to ensure that the process is fair.
So
if
does
it's not,
it mean...
well, it's going to lead to a review application. I beg your pardon, yeah.
Apologies for interjecting there. So does it mean that yesterday's proceedings could be opened up to legal scrutiny here, which could end up seeing the whole report at the end being overturned?
Well, I think we have to say the proceedings have to be fair. And if it's conducted in my absence as the public protector, then definitely we are opening an avenue for me to pursue later on to say, well, I want this to be set aside because it was procedurally unfair. You impaired my rights as a person being accused of certain things, and the Concord having ruled on this aspect, you impeding on my rights to be properly represented in these proceedings, and in fact, you continued in my absence. That evidence wasn't tested. That evidence wasn't ventilated by a legal team. So without a doubt, we are opening an avenue for possible later litigation, which actually should not take place.
So you're saying that particular summary, if her legal representative was in the House yesterday, what possibly could have happened that they could have challenged certain aspects of that summary, as Advocate Bauer spoke about, perhaps her overly suspicious mind having led her to conclude that there was corrupt conduct on the part of the president. You believe that he would have interjected in certain instances while Advocate Bauer gave that summary?
Mfundo, I think it's difficult to say what he would have done. If her rights were impeded during that process, then definitely you could have expected Advocate Mkhwebane to have opposed it, or to have given another context to it, or maybe to have raised something encountering what is being said. If it's just a summary, let me just say this, one has to ask yourself, well, if it's just a summary, to what extent is it impeding my rights? If it's just a summary, of course, we can repeat the summary when you are legally represented, but I would be extremely cautious to proceed with proceedings in the absence of her being legally represented at this stage, because you're just opening a door that should actually be closed shut.
And ordinarily, what we've come to know is that what would have happened is that the oral evidence would have been led in its entirety, and only at the end would then we have Advocate Bauer coming in to summarize. But is she without remedy in this instance, just on what happened yesterday? Could she not, because it was read into the record, we believe, could she then not, or her lawyer, go and just get a transcript of just that which was stated yesterday and perhaps challenge it at a later stage when they've now finalized the funding aspect?
Mfundo, I think you're spot on. That's why I said one has to consider the weight of what happened yesterday. If we're just talking about a summary, absolutely, that summary can be scrutinized by the legal representative with the transcript. He can go through it and he can maybe give another context to it. So absolutely, he would have the opportunity of dealing with it, because we're not talking about cross-examining a witness. We're not talking about putting your version to a witness or giving different context to the evidence presented by a witness. And for that reason, one would have to say the weight of the summary is much less than somebody testifying. So definitely the scrutiny is much higher, and the hurdle that must be surmounted is much higher when we talk about witnesses giving evidence versus just giving a summary and just saying, listen, this is what I think transpired, let's just give a summary. However, you are encroaching upon a dangerous, treacherous field by pursuing a process where she's not legally represented. So in all respects, I would be cautious. And I would definitely, if the proceedings reconvene, I'll definitely say, wait, ma'am, before you proceed, let's just make sure, have you got an attorney today or have you got an advocate today? And let's deal with what was presented at the end of yesterday or during yesterday when your attorney wasn't present. Do you want to add anything? Do you want to say anything to that? And just make sure that you cross the T's and dot the I's, because you don't want to leave things unattended, because then it just opens it up to further review applications, and we don't want it.
And then just in closing, to the summary itself, there were aspects where Advocate Bauer went on to highlight the fact that the suspended public protector relied on incorrect aspects of the law. She relied on PRECA in one instance when talking about the money laundering finding, but then went on to quote POCA, which is the Prevention of Organised Crime Act. What did you make of just that, where she felt that a prudent lawyer would have known better than to confuse the two acts?
Yeah, I understand that what he's trying to do is to highlight certain deficiencies in her competency as the public protector. And once again, it brings me back to, should that be done when she is now on her own? Is it something that we should now raise when she is on her own, not legally represented? And of course, you and I will, and the public will immediately argue and say, but wait a minute, she's an advocate herself, so why does she need legal representation? Why does she need somebody to give context to it? And keeping in mind, even if a judge is prosecuted in a court of law for a criminal offense, he's entitled to legal representation. He's entitled
we saw it with Judge Hlophe. We saw it with Judge Hlophe. He actually spared no cent. Absolutely. He went and got somebody abroad to represent him.
Absolutely. So we must remember the fact that I am legally trained does not preclude me from being properly legally represented. And especially when I, as the witness adducer, if I can call it that, the person adducing evidence, if I want to now draw inferences about your competency based on your conduct, I would be very cautious. And I would say, listen, let's just hold on. Let's get your legal representative. Let's deal with this properly and let's argue this matter. Not that I'm not saying the proceedings have been tainted, but I'm just saying it could easily go down that avenue, and it could easily be argued that, wait, this process was never fair. And it wasn't fair because A, B, C, D, E. And hence, I want the court to intervene and set it aside. And what happens then? Then either it's set aside as a whole, or it has to start de novo. And that's the last thing we as the public want.
Well, certainly not, especially after the amount of money that's already been spent. Mr. Du Toit, thank you very much for your insights this morning. That's legal expert Marius Du Toit.